All right, and we're back. Take a look at the chat. Play game for fun. Dr. Metaverso, Tom Voxel, Jazz Wolf, Yuma. Hey, Yuma. King Charles. Thank you all for being here. Thank you for listening, whether you're lurking or not. We just went over the Memo of Association. Looked a little bit like this. There were 11 sections in all, and it basically told you how it was created and what it was created for. How it gave high-level limitations that you shall not cross, like gifting yourself a bunch of bored apes or 100,000 sand unreasonably. So a really good document. Now we're going to get into the Articles of Association, which is still part of the Constitution. All right, so Articles plus Memo equal the Constitution. Not to be confused with the Constitution that SIP 3 calls the Bylaws. Not to be confused with that. Okay, so that's not the Constitution we're talking about. We're talking about the Constitution as described in Grand Cayman Island law. Right? So for us, our Articles of Association are also located in SIP number 2. So here is SIP number 2. If you scroll all the way down to the bottom, you'll see Articles of Association. So we're going to go ahead and click that. And here it is. So we're going to zoom in. And just like we did for our Memorandum of Association, we're going to be recording our questions as we go. This one's going to be a little bit longer. And here we go. So the very first thing you notice that's different is on the top left, there's that duty stamp. Now, as we learned in 56, actually, you can look at this stuff now. Let's go. In 56, we had the fees, right? There was a fee schedule. And it actually listed 50 as the fee. Where was that? No. There it is. So in Companies Act, page 30 through 35 and section 26 under registration, the registrar shall make available stuff. The required particulars are $50. Where else was that? It was in another. There's a fee schedule. It's one of the amendments. Excuse me, the exhibits. So in that, we paid a $50 duty stamp. Okay, so that's why you see that there. Now, is that number the same as the other number? It should be. 404930 is our registration number. And it is. Same date, same stamp. Great. Articles of Association of Sandbox Foundation, a foundation company limited by guarantee without any share capital. So we already went over that. Same stuff. There's our registered office. Same thing as what we went over. 103 South Church Street, and it's by International Corporation Services Limited on the Grand Cayman Islands in Georgetown. Page 2, Articles of Association of the Sandbox Foundation, a foundation company limited by guarantee. Section 1, Interpretation. What you all may have seen in my episode 56 is I love the definitions part. The definition thing will tell you so much of something before you even read it. All right, so here we have a definitions in section 1. Section 1.1. In these articles, unless the context requires otherwise, founder Oh, that's right. We had a question I forgot to ask. Let's update our questions. My bad. I don't know if y'all noticed, but in section 11 of the memo, the very first sentence read, "This memo and the Articles of Association may be altered by the founder." Do you all remember seeing that word before? No, we had never seen that word before. That's the first time we've seen that word. So let's go back to our questions. Page 4, section 11 of our memo. What is the role of the founder? I have a feeling that part of that question will be answered here in the articles, but you know what? That's not the real question we want to ask. Why is the founder role only mentioned here? It seems like a minor role, I guess. Minor role, or it just seems like it's not really clear what the role does. It's not clear who this is, who or what this is. All right, great. That's a good question. We need to ask that. All right, let's go back to our Articles of Association. So in these articles, unless the context requires, section 1.1, founder means the founder named in these articles. Okay. Laws means the Foundation Companies Act revised, the Companies Act revised, as applicable to the foundation companies, and every statutory modification or reenactment of them. So the reason why I think they put revised here is because they're not just putting themselves to one revision. So the ones that we did in episode 56, the latest versions were 2003 revised, Companies Act 2003 revised 2024. All right, and then we had the Foundations Company Law of 2019, I think 2017, 2019, revised 2024. So when they say revised here, when 2015, or I'm sorry, when 2025 version comes out, then it will automatically be inducted, is what I read here. In fact, let's make that our first question. It's kind of like it's not a big deal of a question, but just because I really want to know at this point. So that's our first question there. All right, so page 2, section 1.1. Does the mention of revised mean that it always references the latest revision of Foundation Company Act and the Companies Act? So Companies Act of 2023, Foundations Company Law, Foundation Company Act of, I think, 2019. Let's take a look. Foundation Company Law. So FCL, right? So FCL of what? Let's put 2019. Oops, you all can't see what I'm doing. There we go. Is it 2019? No. Is it 2017? Yes, 2017. Revised, 2023, excuse me. So there wasn't a 2024 revision yet, except for CMA, which was the Companies Management Act. That was revision 2024. So this is a great example of that. I was reading from, and I did my whole analysis on the Companies Act of 2023, revised 2023, and the Foundations Company Law, also known as the Foundations Company Act of 2017, revised 2023. So does this revised thing here mean that it will always incorporate the latest revision? So if 2025 comes out, does it automatically induct it? I think that's what that means here. Okay. This is a nerd question. Just I want to know. Means the Foundation Company Act revised and the Companies Act revised as applicable to foundation companies and every statutory modification or reenactment of them. Maybe that's what that last part means. Every statutory modification I think modification might refer to revision, but we'll ask. We'll ask. That's why we have legal advice, is to clarify these sorts of things. Next, here we go. Ordinary resolution means a resolution passed at a general meeting of the foundation company by a simple majority of the votes cast or by a written resolution in writing under Article 9.7. We won't read through it all right now, but let's look at Article 9.7. 9.7 is a resolution in writing. Okay, so we're going to talk about resolutions toward the end. Actually, you know what? Let's read that because it's mentioned twice here. So this was the definition of ordinary resolution by a written resolution in writing under Article 9.7. So let's look at 9.7. A resolution in writing signed by all persons for the time being entitled to vote at general meetings shall be as valid and effective as if the same had been passed at a general meeting of the foundation company duly convened and held. Okay. Okay. So this basically means that a resolution, if you write a resolution, maybe by email or by Discord, has the same effect as them being passed at a general meeting in person or on Zoom or whatever. Cool. All right, so that was ordinary resolution under section 1.1. Special resolution. Let's go back to ordinary resolution. So that means 50, greater than 50%. So like 50.1 or 51% of the vote is simple majority. Special resolution means a resolution passed at a general meeting of the foundation company by not less than a 2/3 majority of votes cast or by a resolution in writing under Article 9.7. So this requires 2/3 majority. Same thing. And it references the same Article 9.7, Section 9.7. The word written and in writing include all modes of representing or reproducing words in visible form. So that could be Discord. That could be discourse or forums. That could be Reddit, even, I guess. It could be whatever it is you want where the words are reproduced in written form, visible form. And then section 1.2, except as provided above, the words and expressions defined or used in the laws have the same meaning as in these articles. Okay. Okay. So they're saying all the stuff that we went over in section and this one, podcast 56, all of these rules and definitions have the same effect. Right? They're the same meaning in these articles. Okay. Section 2, preliminary. Section 2.1. The business of the foundation company may be commenced immediately upon registration under the laws. Foundation company's general nature of business is holding company securities. And unless otherwise resolved by the directors, its financial year end is 31 December. Okay, this is a great reason why I read it from scratch again, because I overlooked this the first time I read it. I didn't fully understand because I didn't do episode 56 yet, where I read through the law in its entirety. Having read through the law, I am now wondering about this. Yeah, that right there. That sentence. Let's make that a question. Page 2, section 2.1. Please explain the nature of the sentence. I'm gonna word this very carefully so that it is explained very carefully because of current regulatory environments, all sorts of wise reasons why. Please explain the nature of the sentence. The foundation company's general nature of business is holding company securities. And we already asked in one of our questions, does the Securities Investment Business Act apply? Okay, so now we definitely want to know because that sentence makes it seem like it might. Whereas in my original assessment, I didn't think it did. But, all right, now we're going to say C question 4. And we ended with question 8, so this is going to be question 9. See question 4. All right, so I'm going to put that one in blue. Actually, you know what we're going to do? We're going to take a page from what we've been doing before. Oops. We're going to highlight some key words. Okay, so this is what we were doing in our reading, and it was very helpful. Okay, so VASP. Right, remember when we were going over this, and when I was reading through everything in SANDDAO 56, I made special words, keywords blue, so that we could keep track of stuff in a sentence. That became hugely helpful later on. All right, so I highlight them in green, and then the blue was what the key parts were. So we're gonna do that. We're gonna highlight them in green so that we can keep track of everything. That's what we're going to do. All right, let's start first with our questions. So articles. So VASP is 1. All right. Foundation. DAO Foundation. That's 2. What's next? Director was 1. DRLL was another. It's a Director's Registration and Licensing Law. SIBA, Securities Investment Business Act, is 1. TSP DAO Foundation is another. Oh. And who are the beneficiaries? So SanFam was 1, and beneficiaries was another word. So this helps kind of clear away the cobwebs later on. All right, and then what's our next part of questions? DAO assets. So land, sand, NFT collection. That could be one. Let's do assets though. So the DAO's assets. Foundation staff. Cool. Next one was memberless. Profit incentive shareholders. Right. So required by fiduciary duty. So this is the here, we're gonna make this blue because this is the heart of the question. And the director is a key phrase, keyword. Founder is another keyword. And here we go. There we are. You know what? Let's do this. Be consistent. All right. Now we are on our questions for articles. Okay. So the bylaws. Here are the laws, the Foundations Company Act and the Companies Act of 2017 and 2003, respectively. Please explain the nature. So there's foundation company. That's another keyword. And securities. Is that a keyword? That's going to be a key phrase. So we're going to make that blue. We need to know the answer to that one. Or at least we're going to ask and see if it can be answered. There's that. All right, let's return back to our articles. The foundation company, okay, this is section 2.1. I'm going to read it again. business of the foundation company may be commenced immediately upon registration under the laws. The foundation company's general nature of business is holding company securities, and unless otherwise resolved by the directors, its financial year end is 31 December. Section 2.2. The foundation company may ratify any contract. The foundation company may ratify any contract or other transaction entered into its name or on its behalf prior to registration. Section 2.3. The preliminary expenses of incorporating the foundation company shall be paid by the foundation company, including any expenses concerning any contract or transaction ratified under Article 2.2. All right, what was 2.2? The foundation company may ratify any contract or other transaction entered into its name on or behalf prior to registration. So in 2.3 here, where we just talked about the preliminary expenses, remember that it comes from the guaranteed amount from the original members. That's limited by guarantee. And also, if those people are called upon to pay the debts as is required by the Companies Act, then per the exempted rules, the Memo of Association determined that that repayment would be $1, maximum of $1, meaning that whatever is in the foundation company's assets book is the maximum that they can pay, plus $1 of the original members. Pretty smart move. Seems like a good way to protect our people. Okay. Now, section 3, the founder. All right. The founder. We learned in episode 56 that the founder was only mentioned in the template of the foundation's company law. And we were very puzzled by that. I was very puzzled by that. Why was that the case? Why is the founder only mentioned in the template, which is optional in a foundation company law? Didn't make any sense to me. So I really want to know that. Didn't get a chance to ask our Cayman Island lawyer guests in episode 59. If I'm able to get them back on for Q&A, perhaps I will ask them that. Why is it there? Why is it only there? But here in our Articles of Association in Section 3, we have where we're going to define the founder. So Section 3.1, the founder is International Protectors and Advisors Limited of Harbor Place, 2nd floor, 103 South Church Street, P.O. Box 472, Georgetown, Grand Cayman, K1 1106, Grand Cayman Islands. Okay, so the founder is IP&A. Now, if we recall, IP&A, right, should have been the one. Nope. Let's go back to SIP 2 because I believe that's where we mentioned it. IP&A. There we go. Cayman Island law requires for all foundation companies as well as the company secretary and other services. IP&A is the founder of the foundation. The foundation has engaged IMPA to serve as supervisor. Okay. So IP&A, I believe, is Michael Robinson's company. I think. I'm pretty sure it is. I thought I remember seeing that somewhere. Maybe it's in the entity search that I have later. So let's make that a question. Okay? So our question is page 3, section 3.1. Is IP&A, so per SIP 2, no, is IP&A the company led by Michael Robinson, which is the director? So is it all the same? Is it all the same people there? It's not a bad thing. Just need to know. It'd be nice to know that. All right, so IP&A is a key phrase, they're a key person, and that Michael Robinson is as well, as is the director's position. All good things to know. All right. Next up. Section 3.2. The founder has the following powers, each of which is described in more detail elsewhere in these articles. Okay. Section 3.2a. The founder has the power to authorize the admission of members or to restrict or prohibit the admission of members. See Article 4. Article 4 is the members. Okay. Section 3.2b. The power to appoint or remove directors. See Article 5. Okay. So the founder is already proven to be. So Article 5 is directors and officers. These are some key positions. Fascinating. Who is the founder? Because this person already has an enormous amount of power. Section 3.2c. The power to call for reports, accounts, information, and explanations from the directors. See Articles 5 and 13. So Article 5 is directors and officers. Article 13. Let's keep on going all the way down. Is accounts. Okay. Section 3.2d. The power to appoint or remove supervisors and to settle their powers and duties. See Article 6. I have a feeling Article 6 is going to be supervisors. It is. Supervisors. Okay. Section 3.2e. The power to designate beneficiaries, give directions as to their benefits, grant them enforceable rights, and to revoke or vary the same. See Article 7. Big bet that that's the beneficiaries. Article 7. Yep. And because I know Article 8 is mentioned below it, Article 8 is secretary. All right, so Section 3.2f, the right to receive notice of and attend and to vote at general meetings of the foundation company. Okay, let's look at what Article 9 is. Article 9 is general meetings. Section 3.2g, the power to cause the foundation company to be wound up. Oh my gosh. Wound up is liquidated. The founder has the power to liquidate the company, to close it all down. All right, Section 3.2h, the power to adopt, revoke, or vary bylaws. See Article 17. So let's look at 15. I forgot to look at that. Winding up. It's going to be fascinating. And Article, was it 17? Bylaws. Okay. And remember, we learned in episodes 56 and 59, bylaws are optional. They are not required. And people who do business with a foundation company are not required to adhere to a foundation company's bylaws or consider it. Okay. And then Section 3.2i, the power to adopt, revoke, or vary the Memo of Association and these articles. So see Article 18, alteration of memos and articles. This section / Article 18. Okay, holy smokes. So here in Section 3.2, the founder has the following powers. It seems like they have every power. The founder can almost do anything, it looks like. They can authorize and revoke members, directors, supervisors, beneficiaries. They are allowed to call people to give reports. They're able to dissolve the company, to close it down. They're able to change the bylaws. They're able to change the memo and the articles of association that we're reading right now. This is like everything. So who is the founder? The founder is International Protectors and Advisors Limited. Who are they? When we do an entity search, you will see. What I don't think I found when I did the free search, the online free search, was who led it. I don't know. We'll have to check. That right there is an enormously powerful position. So let's do this. Page 3, Section 3.1. Oh, I already did that. Is IP&A the company led by, is the company IP&A led by Michael Brown's director? If not, who is? Right? So who is the company owner? That is the key to Sandbox DAO Foundation, apparently. That founder position. Okay, let's keep going. Section 3.3. The founder's powers are free of any duty and may be exercised for the founder's own benefit. I don't know what that means. Free of any duty. Does that mean duty of like fiduciary duty? Let's ask. Does free of any duty mean fiduciary duty? Duty? What else? And maybe exercise for the founder's own benefit. Okay, second question. Right, remember how we just read in our memo of association, section 9? We just had this great... No, not that one. Where's the one about the remuneration? There. Section 6, how people can't just give themselves stuff if they want to. Does this mean that in page 3, section 3.3 of the Articles Association, that where it says maybe exercise for the founder's own benefit, do they get to disregard that? Own benefit mean they get to disregard the Memorandum of Association, page whatever, section 9. What is it? Page 3, section 9. There we go. Super, super curious. That doesn't mean anything's going bad here. It just means that the founder, who is an optional role, has been given very, very big power. A lot of power. Okay. So what else we got? This is a key phrase. So we're going to make this one blue. And founder is a role, a keyword. So we're going to make that. So we're going to make that highlighted. And then MOA, page 3, section 9. Also. Okay. Let's go back now. Section 3.4. The founder may, by notice of the foundation company, revocably or irrevocably terminate or restrict any or all of the founder's powers. If the termination or restriction is expressed to be irrevocable, it may not be altered or revoked directly or through an alteration of these articles. I'm seeing a little bit of a contradiction here. I don't know. I'm not a lawyer, so I'm not sure. But let's go page 4, section 3.4. Is there a contradiction here? The founder may irrevocably revoke her own powers, but has the power in section 3.3 to what was the section 3.2 to, where was it? Receive notice. Section here, I, the power to adopt, revoke, or vary. So they can change it however they like. So if they irrevocably revoke their powers, can they overrule their own revoking of the powers? Or because they revoke the powers, they're now kicked out and they don't get a chance to go back in? I don't know. Under section 3.2I, to change MOA, do they get to change the articles? Wait a minute. It just says articles. Oh, and these articles. Yeah. And AOA. However they want. So its keyword is founder. MOA and AOA are also keywords. And then, yep, there we go. All right, so that was that's a question. It does say at the very end here, directly or through an alteration of these articles. So maybe the answer here is no, but the fact that the founder has the power to change itself whenever it wants, it sounds like. I mean, can it change the words? The other section saying that it can't change the words. I don't know which one wins out there. We would need lawyer support. Okay, section 3.5. The founder's powers are not assignable, meaning they can't be transferred to someone else, and except as permitted by these articles or required by law, may not be exercised by any other person on behalf of the founder. Okay, so the founder may not designate someone else to have its own, to have the powers, which, as we learned, are like God powers. This is the God mode right here. The founder. Okay. Section 3.5. The founder's powers are not assignable, and we just read that. Never mind. Section 3.6. Upon the founder's winding up and dissolution, the founder's powers shall terminate. See, this is why I'm saying, okay, we need to add this to the question. So it's not just section 3.2i, it's also section 3.6, which says the founder's powers terminate when the company gets dissolved. But here it says that it could be irrevocably terminated. I don't know. This seems like a contradiction going on here. So I'd like to know. It says it only terminates upon winding up. Okay, so we'll modify our question a little bit. Winding up is a key term as well. All right, so next. We're on question 16. We're about a third of the way through. All right, so section 3.7. The exercise of the founder's powers does not cease to be effective by reason only that the founder is subsequently wound up and dissolved or ceases to have the power. What the? Oh, okay, I see. I see what's going on here. So if the founder says, I'm going to replace the director, and before the director is replaced, okay, let's start over. So if the founder says, in accordance with the power granted section 3.2b, the power to remove or appoint directors, if the founder says, I'm going to remove the director and appoint a new one, and before that director is appointed or removed, the founder decides to irrevocably terminate their own power, then that founder's power does not cease to continue. So I think this means that that director will continue to be removed and the other one will be appointed. And that can't be subverted or changed just because the founder ceases to have power. Right? So the founder can't leave and then you say, no, we're not going to follow that. I think that's what this says. Let's ask. Page 4, section 3.7. Does this mean that if a founder makes a decision and then their power terminates, the decision must be upheld after they leave? And so our example was remove a director, declared a director to be removed, and then the founder leaves before the director is removed. And maybe we won't use the word director because I hope we get the director to. I hope we can interview the director, perhaps. So let's choose a member. Declare a member to be removed, and maybe not removed. Let's go appointed. appointed a new supervisor. There we go. And then the founder leaves before the supervisor is appointed. There we go. That's a more positive example. All right. So let's put in our keywords. So founder is a keyword. Supervisor is a keyword. Founder again is a keyword as a supervisor. Okay. And that was section 3.7. So that's the end of section 3. Now so we just described the founder who has God mode powers apparently to change everything. And there's a little bit of confusion on my end, at least, as to how the founder's power gets terminated. Can it reverse its own termination? There's some things here that it's a little confusing. So we put that. So we put that here in section or in our questions. Okay, so articles, and now we're on section 4, members. Section 4.1, the initial subscriber to the Memorandum of Association shall be the first member of the foundation company. Okay, very good to know. So as we learned in SANDDAO 56, a subscriber is required to start the company. That initial subscriber, in this case, has been determined to be the first member of the foundation company. Very good to know. So who is that initial subscriber? You could see at the very bottom who that was. International Corporation Services Limited. That was the authorized signature. And there it describes the subscriber. So this company, ICSL, is the subscriber, which we know as a result of SIP 2. We have engaged ICSL to serve as secretary and register office provider under the articles. Where did it say? I don't know who ICSL is actually. Oh, wait. I think we figured this one out when we did Birth of the DAO. So what we did was we looked up. Y'all can't see what I'm doing. So if y'all remember, we did a little investigation. Here it is. All right, so we think that ICSL is part of or an offshoot of Travelers Thorpe Alberga, and then yeah. So let's zoom in a little bit. So this was back a while back ago, but we believe that ICSL, because we looked at Duns and Bradstreet, that ICSL is owned by Travelers Thorpe Alberga. So when we looked up Dun and Bradstreet, we saw that the key principal was Michael Alberga. Can you read that? There we go. The key principal is Michael Alberga. This is for ICSL. And we also looked up the documents that we're reading right now. So Travelers Thorpe Alberga being the keyword there, he is one of the founding partners or is a partner for Travelers Thorpe Alberga. So that tells me that ICSL is being run by the legal counsel for the foundation. Did we already asked that question? Oh, we asked IPNA. Who is IPNA run by? And let's see, did we already know that? Yeah, we don't know who that is. So that's still a good question. But let's also put as a sub question here, not a sub question, sub answer. We're in the articles, right? We're in the articles, right? So let's just put in here, because we already know the answer. ICSL is owned by a partner of TTA. Okay, so let's copy paste that part in so that we can remember this in the future. We already did this. We already did this work to figure this out. All right. So it's not exactly listed here, unless somewhere where it describes TTA. The foundation has engaged TTA to advise. Oh, you all cannot see what I'm doing. Hold on. There we go. The foundation has engaged TTA to advise on the foundation's formation and on legal matters related to Cayman Island law going forward. Professional directors require experienced legal counsel. Okay. TTA has extensive experience in the formation and operation of DAOs and is qualified to serve in this capacity. DAO will ratify the appointment of TTA as Cayman Island legal counsel. Okay. So that's where we determined, Michael Alberga. That is the same Michael Alberga in, where's the link? Traverse Thorpe Alberga. Give me a second, let me find it. All right, so Traverse Thorpe Alberga. Here's the law firm. And if we go to our people, we shall see right there, Michael Alberga under Traverse Thorpe Alberga. So if we click that, it will bring us to Michael Alberga, managing partner, Cayman Islands. Okay, so that's how we made that connection. And again, nothing wrong, nothing weird going on here. Seems like that was contemplated in order to successfully stand up and create our DAO. Okay, no problem. Makes sense. At the time, we thought it was suspicious, but the more we actually educated ourselves on this, the more we got people, lawyers, lawyers to be guests to explain things. And we delved into the laws and we read through stuff, nitty gritty. It's not quite so weird anymore. Like, I don't think there's anything really going wrong here. Okay. So we are. Oh, we were updating our question. Right. We were updating our question. So ICSL is owned by but let's look at the exact language. What is it? What does Dun and Bradstreet say? Key principle. Okay. So you always want to err on the side of using the source's words. That it can get a little conflicting. Like, does key principle really mean owned? Sometimes it doesn't, which is why you want to try not to interpret or paraphrase for someone else unless you actually know or hear what they've had to say. So the key principle for ICSL is Michael Alberga. And as we saw, Michael Alberga is a managing partner. So good to know. And as you read in SIP number 2, Traverse Thorpe Alberga has extensive experience in DAOs. So the way that they're doing it here seems to be tried, true, and tested. They also seem to have a lot of offices. New Zealand, Australia, Hong Kong, London, British Virgin Islands, Cayman Islands. Okay, cool. So let's go back. So now we're on section 4. We just read 4.1. The initial subscriber to the Memo of Association shall be the first member of the foundation company. Cool. Now we know what that means. The subscriber is the one who initially creates the company. And then that's the first member. I wouldn't be surprised if that first member also became either the founder or the director. Unsure. We'll keep reading. Section 4.2. Subject to these articles, the directors may, if so authorized by the founder or by a special resolution of the foundation company, Admit as a member any person who has applied for membership in writing, and the terms of admission may restrict, enlarge, or exclude any or all of the voting and or rights or powers of members under these articles, or provide for termination of membership at a specified time or in specified circumstances. Cool. I wonder if the special counsel or advisory board are members. Let's ask. Let's ask that question. Page 4, section 4.2. Is the SC or AB members? Okay. And the second question would be, did the initial subscriber become the founder or director? All right, so we're trying to connect some dots here. It's helping us understand how this is run. Right? If not, what are they? Are they beneficiaries? So then our 18th question, did the initial subscriber become the founder or director? Okay. Well, that was, well, both of those are 4.1s. No. Here we go. Fixed. All right. Now we're on next up, question 19. Okay. We just read through section 4.2. Now we're going to 4.3. The founder, by notice to the foundation company or the foundation company by special resolution, may restrict or prohibit the subsequent admission of members. If the restriction or prohibition is expressed to be irrevocable, it may not be altered or revoked directly or through an alteration of the articles. But it sounds like the founder can irrevoke it. It's not like the founder can change anything. All right, so page 4, section 4.3. But the founder can overturn this irrevocable prohibition. So can the founder overturn this irrevocable prohibition? See how all this stuff, this is how these things are done. This is how you determine what really goes on. So when I was showing you all earlier over here, when I did my relationship map in SANDDAO 56, this triangle of confusion I said. So let's go back to it. Ready? Here we go. Oh, that's not it. That's not what I'm after. Hold on. The link must be broken. My triangle of confusion. Yeah, whoops. Was I didn't know the relationship of everyone here. And then I expanded upon that in SANDDAO 57, where we talked about this flow chart. And it said SANDDAO 57 looked like this, or 56, excuse me, looked like this. And I upgraded my triangle of confusion to my rectangle of confusion because it still wasn't clear. Although we knew who else was doing stuff, we knew more of what was going on. We still didn't exactly know how they all played together day to day. And SANDDAO 59 with the lawyer guests, They helped explain a little bit of it, but we didn't get time to the question and answers to figure that out. So that's where I want to know what actually is going on between all of these people here. What's going on here? And after SANDDAO 59, we are able to clarify that a little bit, but it's only this part on the left. Right? All we know is more of what happens on the left. I still don't fully know what happens on the right. So I'd like to do an interview with the director, Michael Robinson, if we can. I'd like to do an interview with, have one of them on. I think that'd be really cool. So they can kind of give us some guidance. What really goes on there? Okay. And we are here. All right. And I know we want to. How do these positions interact day to day? So that's a question we want to ask of what? Which section? We want to ask this of section in general. This is going to be a general question. But we're going to ask it here while we're in the members section. There we go. Okay. That sounds good. And let's go. Yeah, you know what we're going to do? So here, we're going to take our rectangle of confusion. And then we're going to paste it in here so that we remember why it was we were asking this question. Okay, so I pull open that. I go like this. And then let's crop it a little bit. All right, so this is so we can remind ourselves why, what are we referring to? In case I need to later on. Okay, that's our general question. We read, what did we read last? Founder by notice the company. Okay, yeah. So we may restrict and prohibit the subsequent admission of members. So that general question actually is going to be a question for section 4.3. Section 4.3. May restrict or prohibit members. All right, so we want to know more about this. How do all the positions interact day to day? There we go. All right, now section 4.4. A person's membership of the foundation company terminates. Section 4A, or section 4.4A. If the person dies or being a corporation is dissolved. Section 4.4B. If the person resigns as a member by notice to the foundation company, the resignation shall be effective immediately unless the notice states otherwise. Or Section 4C, as provided in the person's terms of admissions as a member. Okay. Section 4.5, it is not a condition of this article that the foundation company continues to have one or more members. Okay. Section 4.6, the rights and powers of members are not assignable, meaning transferable to someone else, and except as permitted by these articles or required by law, The rights or powers of a member may not be exercised by any other person on behalf of the member. Okay, so same thing as the founder. Section 4.7, the rights and powers of members are free of any duty. Now that sounds very familiar, but changed from the founder. The founder said the founder's power in Section 3.3 are free of any duty and may be exercised for the founder's own benefit. So what does not including that mean? I think we asked that question already, didn't we? And maybe exercised for the founder's own benefit. So, and we're going to put reference 3.3. Okay. So we want to reference 3.3 there, where members don't have this. Okay, so we're going to put that as blue. So not blue. There we go. That one. So that one will tell us. I put that in as kind of like an aside. So we can ask that later. Okay. So we're in section 3.3. Now we're in section 3.4. The founder may, by notice to the foundation company, revocably or irrevocably terminate or restrict any or all the founder's powers. If the termination or restriction is expressed to be irrevocable, it may not be altered or revoked directly or through an alteration of these articles. Isn't that? Oh, shoot, my fault. I skipped. I went back on accident. That was section 3.4. We already read that. Let's go to section 4. We read through all the members. We went through section 4.7. The rights and powers of members are free of any duty. And that's where we went down that other rabbit hole. Okay. Now we're on section 5. Directors and officers. The foundation company, section 5.1. The foundation company shall at all times have at least one director. Okay. Good to know. That's consistent with what we learned in SANDDAO 56, where you had to have a director and a supervisor and a secretary. And the secretary had to be licensed in accordance with the Companies Management Act. All right, section 5.2. The first directors may be appointed by the subscribers to the Memorandum of Association. There we go. That tells you the power right there. Let's go back to what question? Did the initial subscriber become the founder or director? So we want here is a reference, section 5.2, where it says first director may be appointed by the initial subscriber. See, this is starting to really paint a picture. You're starting to see how the relationships are playing out. I just don't know how it plays out day to day. I know how it's described here and it's starting to play out this way. I don't know the rest of that. Okay. So we want to reference 5.2 where it says the first director may be appointed by the initial subscriber. So does this work in the way that our lawyer guests in SANDDAO 59 said, where it's first director led and then token holder led? If y'all recall, it was here. It was here that we did that. Director led, token holder led, and under the timeline of events. And that was this one here. We just did it just the other day with Melissa and Carolyn. Okay. Now we have it's saying in section 5.2, the first director may be appointed by the subscribers to the Memorandum of Association. Section 5.3, the founder has the power exercisable by notice to the foundation company to appoint or remove directors, including the founder if the founder is one. Okay. So the founder can remove themselves as directors. Okay. I'm confused as to why we had to call this out here, but okay. I guess it's just to remove all doubt, I suppose. Section 5.4. By ordinary resolution, which means simple majority, the foundation company may appoint or remove directors. Okay. So the foundation company, the founder isn't the only one who can remove directors. Apparently, the foundation company may by ordinary resolution. And that was a simple majority at a general meeting. Oh, you all cannot see what I'm saying. Okay. That means ordinary resolution meant a simple majority at a general meeting. And we were just reading these sections. So we read that one, we read that one, and we just read section 5.3 here, including if the founder is one. All right, now 5.4. By ordinary resolution, the foundation company may appoint or remove directors. That's the one we just finished reading. Section 5.5. A person ceases to be a director if removed under the foregoing provisions. Or, okay, Section 5.5a. If the person dies or becomes bankrupt or, being a corporation, enters into winding up or is dissolved. Or, Section 5.5b. If the person resigns as director by notice to the foundation company, the resignation shall be effective immediately unless the notice states otherwise, or there are no other directors, in which case the resignation shall be effective upon the appointment of a further director. Meaning the director can't just leave and no one's there to replace them. That's fascinating. So I guess here it says that they can require that director continue to serve until a new director can be take their place effective immediately. Section 5.6. Subject to these articles and the bylaws, the business and affairs of the foundation company shall be managed by or under the control of the directors, who may exercise all the powers of the foundation company other than those that are required by these articles or the bylaws to be exercised by the general meeting or others. So, do they have the same power as the founders? I guess the part that's confusing me here is may exercise all the powers of the foundation company. And part of the powers of the foundation company is the power of the founder. So it's a little confusing, I think. Let's do a question out of that. 5.6. Does may exercise all the powers of the foundation company mean it can exercise the director can exercise the founder's powers? Here we go. It's a good question. So director is a keyword. Founder is a keyword. Foundation company is a keyword. There. So I just updated and put in question number 19. Whoops. Wait a minute. Oh, I already had that. Never mind. My bad. So we're actually question number 21 now. It's a lot of questions. But this is all the stuff that's still confusing. When I say my rectangle of confusion here, that's what I'm referring to. This stuff. Okay? Section 5.7. The directors shall observe these articles and the bylaws and shall at all times act in the interest of the foundation company and its objects. That sounds a lot like fiduciary responsibility. Is that just a confirmation or is that extra too? Let's ask that. 7. Is this extra to the fiduciary duty or a confirmation of, or affirmation of? Right? Does it reinforce it? Or does it only reinforce it? So we want fiduciary duty. Okay. Section 5.6. Nope, we're just at section 5.7. Okay. Section 5.8. The directors shall give the founder or the general meeting, in parentheses, or the persons who have the right to attend the general meeting, in parentheses, such reports, accounts, information, and explanations concerning the business and affairs of the foundation company, and the discharge of the directors' duties and the exercise of their powers as may be required by 5.8a, notice from the founder, or 5.b, ordinary resolution of the foundation company. So this just tells the director has to give information when asked by specific people. Okay. Section 5.9, the duties of the director are owed to the foundation company only. Section 5.10, directors' remuneration just means compensation or salary, shall be at such rates and on such terms as may be agreed in writing by the founder or by an ordinary resolution of the foundation company. So we already know what this is. We looked at SIP 2, and under resources, required, we see directors is being paid $30,000 annually right here. Okay. This is section 5.8. We just read that. Section 5.9. Section 5.10 is what we just finished reading about the remuneration. Section 5.11. Subject to the foundation company's Memorandum of Association, these articles and the bylaws, the directors may delegate any of the powers which are conferred on them under the foundation company's Memo of Association, these articles and the bylaws. Section 511A. To such person or committee. Section 511B. By such means, including by power of attorney. Section 5C. To such an extent. Section 5D. For such periods or periods of time. Section 511E. In relation to such matters or territories. Section 511F. On such terms and conditions as they think fit. Okay. Section 512. If the director so specify, any such delegation may authorize further delegation of the director's powers by any person to whom they are delegated. Okay, I see what's going on here. So in section 511, the director is allowed to delegate, as in confer or transfer, or also authorize someone the power that they have. Then that person, that's section 511. Then section 512 says the person that was just delegated all that power by the director is also allowed to delegate their power to other people. Right? So you start to get this like tree, right? Director delegates. Let's say to delegate to 2 people. Those 2 people can then delegate to however many, 4 people. All right. Section 513. The directors may revoke any delegation in whole or part or alter its terms or conditions. Section 514. Committees to which the directors delegate any of their powers must follow procedures which are based as far as they are applicable on those provisions of the foundation company's Memorandum of Association, these articles and the bylaws which govern the taking of directions by directors. Okay, let's reread that one. 5.14. Committees to which the directors delegate any of their powers must follow procedures which are based as far as they are applicable on those provisions of the foundation company's Memo of Association, these articles and the bylaws which govern the taking of decisions by directors. Okay. So, in the first part, it says the committees to which the directors delegate any of their powers. So it says they can be delegated to a committee. Okay. Must follow procedures which are based on those provisions of the foundation company's Memo of Association. Okay. And the Memo of Association had the objects, right? So it had the objects and then it had the section below it, which expand on those objects. That's probably what this is referring to. This here, there's the objects under section 3 of the Memo of Association. And section 4 has those A through O things that it can do. I think that's what this is referring to. Okay. This last part, though, these articles and the bylaws which govern the taking of decisions by directors. Oh, that's a comma. Okay. So the committee that has delegated the power must follow the procedures of the foundation company's memo of association and these articles of association. So they don't have to just follow, the objects and here they have to follow all the things in this article as well that we're reading right now. Okay, makes more sense now. 5.15, the directors may make rules of procedure for all of any committees, which prevail over rules derived from these articles if they're not consistent with them. Nice. So if the director decides to make special rules, such as maybe the special counsel code of conduct, I'm sorry, the delegate code of conduct, is that considered a committee? Let's ask. Page 7, section 5.15. Is the TSP DAO's approved delegates, is the code of conduct for the TSP DAO's approved delegate considered a committee? Is SC and AB? So we're going to highlight our keywords here. Code of conduct. And does everyone remember what code of conduct we're talking about here? All right, so if we go to our DAO and we go to delegation, where's our code of conduct? Looks like it's in here somewhere. Adhere to the code of conduct. Code of conduct. Where is this code of conduct? The code of conduct is what every delegate had to. Oh, here it is. Type form. I bet you it's in here. We talked about this. So I'm just gonna work through this. Try and get there. We did this on another SANDDAO podcast when we said the delegation was here. That's what the episode was called. Delegation is here. Which one was that? So delegation is here somewhere. Would have been right there. Episode SANDDAO 28. Delegation has come to the Sandbox DAO. That's the one where I go over this in detail. So if you want to look at what this type form is all about, then just go to that one. And we're looking for the code of conduct. There it is, right there. Let's click this code of conduct. And, oh. Is there a link somewhere that I missed? I must have missed the link. Okay. So we're going to go now to our code of conduct link and link it here so that we know where it is in the future. So this code of conduct is what we're referring to, where the Sandbox DAO delegates were required to adhere to this code of conduct. All right? Good stuff. Good stuff. So the question was, is the code of conduct for the TSB DAO's approved delegates considered a committee? Is this special counsel or AB, advisory board? All right. And we just went over 515, where the directors may make custom rules. All right, 516. Notwithstanding the above, the directors may appoint such officers as they consider necessary or desirable on such terms, as at such remuneration, and to perform such duties, and to subject such provisions as to disqualification and removal as the directors may think fit. Unless otherwise specified in the terms of their appointment, an officer may be removed by the resolution of the directors. Okay. And I don't think SIP 2 talked about the remuneration of the officers. It just talked 50,000 for legal expenses, 30,000 for directors' expenses. So let's actually put this in our slide. Which question was it? Where did we talk about the remuneration? And this is the director, right? Section 5? Yeah, so the directors and officers. So for section 5, we talked about 515. There's our question on 515. Okay, and then we're just going to put a little reference in here. SIP 2, director remuneration. So compensation. Just so we can remember that later. Make sure it goes where it's supposed to go. Oh, having some time. Having some trouble thinking. All right, we'll look at that later then. Okay, let's keep it going. We're on now section 6, almost there, almost halfway through at least. We went through section 5.15, then we went through section 5.16, and that concluded the part about directors and officers. Now we're on section 6, supervisors. Section 6.1, the initial supervisor is International Protectors and Advisors Limited of Harbor Place, second floor, 103 South Church Street, P.O. Box 472, Georgetown, Grand Cayman, KY1-1106, Cayman Islands. Section 6.2. The founder has the power, exercisable by notice of the foundation company, to appoint or remove supervisors to supervise the management of the foundation company. Section 6.3. The founder's notice appointing a supervisor may, Section 6.3a, restrict, enlarge, or exclude any or all the voting and other rights or powers of the supervisors under these articles. Section 6.3b, impose any supervisory or other duty or disability, grant a related exculpation. What does that word mean? I don't actually know what that word means. Exculpation is the act of freeing someone from blame or guilt. It can also refer to a clause in a contract that limits one's party's ability. Is that the same thing as indemnification? Is exculpation the same as indemnification? Let's take a look. Exculpation and indemnification are both contract clauses that shift liability between parties, but they have different purposes. Exculpation prevents a party from recovering damages, receives a party from liability for their own negligence or wrongful acts, relieves a party from liability, and is often used in contracts for dangerous activities such as skydiving or whitewater rafting. Is our DAO a dangerous activity? Okay, let's keep going. Indemnification shifts liability from one party to another. One party compensates the other for losses, damages, or liabilities. Is often used in private fund governing documents to protect managers and affiliated persons from losses. Okay, fascinating. So exculpation again prevents a party from recovering damages, relieves a party from liability for their own negligence or wrongful acts. Okay, these examples include a landlord might include an exculpation clause to limit their liability under release. A gym might include an exculpatory clause in a membership application to relieve the gym from responsibility for injuries sustained while working out. Exculpatory clauses are generally enforceable unless there is specific public interest or statutory exemption. Okay, so let's reread this. Section 63B. Impose the founder's notice appointing a supervisor may impose any supervisory or other duty or disability, grant a related exculpation, and waive conflicting interests or duties. So the founder may grant the ability from one to prevent a party from covering damages or relieving a party from liability for their own negligence or wrongful acts. Okay, got it. Section 63C gives the supervisory rights to remuneration or indemnity by the foundation company. Okay, so not just exculpatory stuff, but also indemnification, which is where the foundation company would take on, like if the supervisor got sued, right? To indemnify them would mean that this founder's notice, which I guess would be conferred upon the foundation company, would indemnify the supervisor, meaning pay for or relieve them of the responsibility, right? So it'd be shifting the ability. So if they get sued, then the foundation company would take on that paying for that suit. That would be compensate the other for losses, damage, or liabilities, that sort of thing. That is to indemnify. To exculpate someone, I guess, means they're not allowed to ask for money. That's fascinating. Okay, 63D. Provide for the termination of the supervisor's appointment at a specified time or in specified circumstances. Okay, very broad. We're talking about the founder's notice. Okay, so that notice appointing the supervisor can have a lot of restrictions, is what we're reading here. Section 6.4. A person who is a supervisor has the power by notice to the foundation company to appoint a person to succeed the person as supervisor immediately or at a specified time or in specified circumstances, with and subject to the same terms of appointment as applied to the appointer, and to revoke such appointment at any time before it takes effect. Okay, so the supervisor may delegate their own person to succeed them. All right, so a person who is a supervisor has the power, as long as they notify the foundation company, to name who is going to replace them immediately or at a specified time in the future. And that the same appointment notification that they got to be appointed supervisor also applies to the person they named that's going to replace them. That's what 6.4 is saying. Section 6.5. A person ceases to be a supervisor if, Section 6.5a, if the person dies or becomes bankrupt or being a corporation enters into winding up or is dissolved. Section 6.5b. If the person resigns as a supervisor by notice to the foundation company, the resignation shall be effective immediately unless the notice states otherwise. Section 6.5c. If the person becomes a director or acquires any interest or duty that conflicts with any duty of the person as a supervisor, unless authorized by the founder or by special resolution of the foundation company, that's just conflict of interest. Let's see if that's applicable to anywhere else. No, the directors and officers have to at all times act in the interests of the foundation company, but it looks like there may be a conflict of interest present for directors and officers, and that's permissible, or at least not covered by Section 5 here. But if you are a supervisor, you may not. Where's that conflict of interest thing? There. You cannot have a conflict of interest. Interesting. Section 65D, as provided in the person's terms of appointment as a supervisor, or Section 65E, is removed by the founder. Okay. Section 6.6, the foundation company is required at all times after the founder's death, or if the founder is incapacitated, to have at least one supervisor who is not a director and is able and willing to supervise the management of the foundation company. If this requirement is not met, the foundation company shall, by ordinary resolutions, appoint one or more supervisors on such terms as it thinks fit to make up the shortfall, failing which the directors shall apply to the court under Section 9(2) of the Foundations Company Act revised. I think we went over this, right? So what was it, the Foundations Company Act? Okay. So in our Foundation Company Act here, Section 19(2). Nope, we didn't. We stopped with Section 17. So in Section 19(2) in the Foundations Company Act covers how to apply to the court. We glossed over that in Section 56. We did it very, very briefly, only because it didn't seem super relevant to us. But here, if there is some sort of shortfall and they need legal remediation, then they can apply to the courts, and the courts generally have a duty to help resolve that. And they have the ability to apply wide range of powers. I know we went over that a little bit. Oh, oops, it was right there. Grand Court functions. Here, Part 5 was the Grand Court's functions, of which was Section 19. The court plays an important role in resolving foundation company disputes, appointing, removing members, conducting investigations. So that's what this is referring to. In Part 5 here is Section 19. That is specified here in Section 6.6 of the Articles of Association. Good to know. So something in here that caught my attention. The foundation company is required at all times after the founder's death, or if the founder is incapacitated, to have at least one supervisor who is not a director? Where did we read that the supervisor is allowed to be a director? I remember reading that. Have at least one supervisor who is not a director, right? Where did we read the supervisor could be the director? I remember reading that. And I think it was in the preamble. All right, so we got a supervisor. We got the director, we got the supervisor again. We got the director again. Here are keywords for this question. This is a fascinating one because I can't remember where we read it. Was it can also? Is also? No. I don't remember where that was. So, reference. Cannot remember where it was stated. So if someone says, I don't remember that, then I'll be like, okay. I'm pretty sure we read that. Maybe it was in the articles or in the memo where we talked about members. No, let's search director, right? Oh, you know what? Supervisor had less. Okay. No, it would have been here in the articles then. The supervisor. Okay, we're in section 6 now. 6.3. Impose rights. Okay, that's where we are now. I don't remember where we read it. We read it somewhere though. All right, let's just keep going. We're in section 6.5, and we just read 6.6 right there. Now we're under 6.7. A supervisor, 6.7a, may require access during normal working hours to the files, books, accounts, and records of the foundation company. Cool. That's a good check and balance of power. Section 6.7b, may by notice of the foundation company call for such reports, accounts, information, and explanations from the directors as to the administration of the foundation company as are described in the notice. So an important thing here to remember is that the enforcement here is if the supervisor does not feel that they are getting satisfaction, they are able to bring an enforcement action against the foundation company. And SANDDAO 59, with the lawyers as guests, did articulate that as part of their brief. It was here, and it was toward the end, I think. Oh, here it is. The supervisor will retain the unconditional right to attend. There we go. And to bring an action on behalf of the company for the enforcement of the duties or liabilities of the directors. And we went over this in SANDDAO 56 when we were reading about the powers of the supervisor. They could bring an enforcement action. And as we just read in here, the Grand Court's function, the Grand Court plays an important role in resolving those disputes, of which could be the enforcement action. So that's how it all kind of fits together there. Cool stuff, man. This is so cool. All right. No question yet. I don't think I have any questions yet. Section, we just read section 6.7b. Okay, section 6.7c. 6.7c has the right to receive notice of and attend and vote at general meetings, and 6.7d shall observe the foundation company's memo of association, these articles, and the bylaws. Okay. Section 6.8, the powers granted to a supervisor under these articles may only be exercised in the interests of the foundation company and its articles. Oh, excuse me, and its objects. Okay, got it. Section 6.9, any duties of a supervisor are owed to the foundation company only. Section 6.10, the remuneration of a supervisor shall be at such time commercially reasonable rate and on such terms as agreed in writing by the supervisor and the directors and otherwise in accordance with its standards, terms of business from time to time in effect. Let's take a look at SIP 2. Did it name the fees for supervisor? Oh, the $50,000 here includes, oops, where am I? There. The $50,000 here includes supervisor, founder fees, and secretary fees. So not just legal fees. Okay, good to know. I wonder, does SIP 1, what does SIP 1, oh Lord, that might take a little bit. All right, we're done with section 6, which is the supervisor. Now we're going to section 7, which are the beneficiaries. Okay, so one of our earlier questions was, who are the beneficiaries? Okay, section 7.1. The foundation has the power, exercisable by notice of the foundation company. Section 7.1a. To designate persons or descriptions of persons as beneficiaries, conditionally or unconditionally. Section 7.1b. To give directions as to the benefits of which a beneficiary will or may receive from the foundation company. Section 7.1c. To declare that the beneficiary shall have an enforceable right to receive benefits from the foundation company or any other rights in or against the foundation company, or that the beneficiary is an interested person for any and all of the purposes of the Foundation Companies Act revised, and Section 7.1d, to revoke or vary any such designation, direction, or declaration. And the founder has so much power. But one of our questions we asked earlier was about who's the beneficiary? Let's take a look. Where did we ask that? I think we asked it in. I think we asked it in the memo. Beneficiary. Oh, there we go. Question number 5. Who are the beneficiaries? And we want to reference Articles of Association, page 9, section 7.1C. Okay, so now we need to make that highlighted. Okay, so if we need to reference what is it about the beneficiaries that we're looking at here? One thing, key point of interest is to declare that beneficiaries shall have enforceable rights and receive benefits. So once we figure out who those beneficiaries are, we can figure out then what sort of rights do they have, because this section 7 says the founder has the power to declare that. Okay, where's that enforceable action thing? That was under the supervisor, right? So the supervisor, we're just talking about here and the beneficiaries, section C. So what was the enforceable part? Uh, shall observe. Did we have a question for section 6.6? Oh, did we read the supervisor? Where did we read that it could be? Okay. Where was the part about the courts? May require access? No. Call for such reports? Oh, it was under 6.7b. Okay. So page 8, section 6.7b. May call for such reports, accounts, all that stuff. And the reference here was SANDDAO 56, slide what? 88. And that was part 5 of FCL, Grand Courts Function. And then also reference SANDDAO 57, slide, oh, not 57, 59, excuse me. SANDDAO 59, slide 40. Supervisor enforcement action. Cool. This is how you weave all this stuff together. All right, so what I'm doing here is I'm weaving together in case I need to go back to it to have a discussion or to do a Q&A. This is where we do it, where we talked about it. All right. All right, let's go back. Call for such reports. Shall observe. Okay. We were in beneficiaries, weren't we? Yep, we adjusted to declare the beneficiaries have enforceable right. So there is another part. So page 9, section 7.1. Oops, wait a minute. Here we go. Page 9, section 7.1, Charlie. And what we're looking at, shall have an enforceable right. And that enforceable right is referenced by what we just went over, SANDDAO 56, slide 88. But also, let's take a look at SANDDAO 59. Did we talk about it there? Let's take a look. It was this one. So there's supervisor. Where did we talk about the beneficiary? Did we talk about it? Beneficiary? Those are all the questions I did have at one point. And nope. So there was no discussion of beneficiaries here. That would be part of the Q&A if we are able to have one. Okay? And it was not discussed. And then let's ask what enforceable right. Yeah. Beneficiaries. That's our keyword there. Shall have an enforceable right, right? So let's figure out what that right is. I think it's the right to go to the courts, the grand courts, but do they get enforcement actions? Okay. Restriction notice. We need to talk about restriction notice. Yeah, need more clarity on that restriction notice thing. It's a general question. And this was, you know what? Let's go ahead and reference the actual slide. When we did our Q&A here, I asked, are they the eyes and ears in this SANDDAO 59? Carolyn said yes, in a sense, but the supervisor is a passive role. The articles spell out this power, which is what we're reading now. And then Melissa said, restriction notices apply to the beneficial ownership regime, which I think was the token, maybe the token holder led phase. I think I need to ask that question. All right, so that would be reference slide, SANDDAO 59, slide 53, which was eyes and ears question. Hey, play a game for fun. Thank you for rating. Appreciate that. Yes, I am still going. I'm still going. I appreciate that. We are about halfway done with the Articles of Association. And this turned out to be a really, really long episode. But it needs to be done and we need to get through it. Appreciate that raid. I play a game for fun. All right. Where did we leave off? Section 7.2. Subject to any unrevoked declaration under Article 7.1c, that would be the declaration to have an enforceable right, a beneficiary does not, as such, have any rights, powers, or interests in or against the foundation company, the founder, the directors, the supervisors, or any property of the foundation company, except Section 7.2a, the right to retain any benefit that has been properly conferred upon the beneficiary by the foundation company, and Section 7.2b, the right exercisable by notice to the foundation company to terminate the beneficiary status as a beneficiary. Okay. Play game for fun in the chat said, try to play as many games as others, creators, especially those who post their experiences on my Discord. Right on. How about you message me on Twitter? Not Twitter, dang it. Message me your Discord link here in Twitch. Whisper it to me, though, because I think my bot will try and time you out if you do that. So just whisper it to me, and then I'll post it here for everyone to see. How about that? Thank you, Play Game. All right, next up. Oops, we are way past that. So 18. Hold up, phone. What's going on? 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. This should be 19, 19, 20, 21, 22. There we go. 27. What? Hold on a second. I think I messed something up. I did. I must have gotten something out of order. This is 19. 16, 17, 18, 19. Okay, good. So we will. There we go. All right, cool. I think we're back on track. 19, 20, 21, 22. This would be 23. Then this is question 24. Page 4, page 5. This is page 7. Oof, I messed up a little bit here. The ordering. Section 4. So it's page 2, section 1, section 3, section 3, section 3, 7, section 4, section 4, section 5, section 5, section 6, section 7, and then there's section 4, 3. Okay, good to go. Now we're on now question 25. 25 questions already. It's a lot. Play game for fun said, oh, I've just realized I forgot to draw the winner on my coin. I'll check there in the beginning of my next stream. If you want to announce the winner here now, Play game, I can highlight your message. I can highlight it here, and then you can alert them elsewhere. Boom, right there. Big old stuff right across the stream. Up to you, though. All right. And Play Game for Fun's Discord. If you want to get involved in the stuff that he does, he streams quite a bit, and he's been a great member of SanFam for quite some time. Take a look at his Discord here. That is Play Game for Fun's Discord, where you can win stuff. Let's try that again. Fun's Discord is that. There we go. Okay, that didn't work, but there it is in chat at the bottom. Go ahead and click it and join and have fun. All right, so now I think I have this right. 4-3 5.6, Section 5.7, Section 5.15, Section 5.6, Section 6.7, Section 7.1, and then there's the general question. Okay. Okay. 9 to 12. Question 13 to 15. Question 16 to 18. Question 19 and 22. Question 23. Good to catch this stuff in the moment. And then question 23, 25, and this is question 26. Holy smokes, that's a lot of questions. All right. So now we're on question 28. And we are now starting to read section 8, Secretary. Section 8.1. The first secretary is International Corporation Services Limited of Harbor Place, second floor, 103 South Church Street, P.O. Box 472, Georgetown, Grand Caymans, KY1-1106, Cayman Islands. I think we already clarified that what this was. So the key principal for ICSL is Michael Alberga, partner of TTA. Yeah. So we'll there isn't any, there. I don't think I have a question here. Section 8.2. The founder has the power, exercisable by notice of the foundation company, to appoint or remove the secretary or any assistant secretary. Okay? So we can have an assistant secretary, it looks like, provided always that there shall be at all times a qualified person as defined under the law appointed as a secretary, and no secretary shall cease to hold office until a qualified person has been appointed in the secretary's place and the registrar has been notified. So we have gone over this quite a lot. The qualified person part, that qualified person is specified quite a bit in section in SANDDAO 56, where we talk about what qualified people means. And where did we talk about it? Here, qualified person, and page 5 and 6 of the Foundation Companies Law, also called the Foundation Companies Act, means a person who is licensed or permitted by the Companies Management Law, otherwise known as the Companies Management Act, to provide company management services in the islands. And so that's a good little reference thing. Reference SANDDAO 56, slide 85, which is FCL. What was that? FCL Part 1, Section 2. 2 means a person licensed or permitted by CMA. All right. Whoops. That should not be highlighted. All right. Where else are we looking for? FCL is a key phrase. Licensed. A qualified person. Oh, it's just a person. Licensed or permitted. These are also key phrases, as is CMA. All right, and the reason why we brought that up was section 8.2. And what was the question here? Was there a question? Assistant secretary can be not qualified. It is not required to be a qualified person. All right, that was the question here. Is the assistant secretary required to be a qualified person? That's our question. Here is a reference. Okay, there we go. And these are reference. Okay. Now we're on question number 29. We are moving right along here. Oh, that's how that happened. Okay, I see now why it got out of order. And then this gets highlighted. So is the assistant secretary that gets as a keyword as this qualified person. It's a keyword. All right. Now we're on section. Oops, we didn't put what the question was for. It was for page 10, section 8.2. All right, next question is our next read, section 8.3. The directors may appoint and remove the secretary or an assistant secretary provided there shall be at all times a qualified person as defined under the law appointed as a secretary, and no secretary shall cease to hold office until a qualified person has been appointed in the secretary's place and the registrar has been notified. Okay. Section 8.4. The remuneration of the secretary shall be, remuneration means compensation, how much are they paid, shall be at such a rate and on such terms as agreed in writing by the secretary and the directors and otherwise in accordance with its standard terms of business from time to time in effect. Okay. Section 8.5. The secretary shall at all times comply with the requirements of regulation laws as defined in Section 2 of the Companies Act, revised, and shall be entitled to receive from the foundation company and any interested person such information as the secretary may reasonably require for such compliance. Now, if you remember what we talked about, the secretary was required to do a number of things. They had to determine and assert a vast number of things. Determine? What was it? Assert? What word did I use? I used a very specific word. I think I pretty much used declaration. I think it was declaration. To declare. There. So the secretary must state no objection when things are given to them. They must assert that no changes, declare that no changes have been made. And when changes are made, they must declare that. They must also what? There's a bunch of stuff that they must declare. Okay, so that's what we're referring to in section 8.5, right there. Section 8.6. Section 16 of the Foundations Company Act revised shall be observed. Okay. What was that again? Let's look at what that was. We looked at all that stuff in the beginning. Section what? Section 16, the Foundations Company Act. Okay. Huh. I don't have section 16 here. Let's take a look real fast. What was that? We know what that is. So we're going to pull open the legislation document and look at section 16. Oh, right. Not part 16, section 16. My fault. I forgot that they do that. So the Foundations Company Law uses parts, but each part has a numbered section number. And the good news is they start with section 1 in part 1, and they conclude with section whatever in part 6, and it's all the way through. It doesn't start over. Like part 2 doesn't start over with a section 1. It's section whatever you ended with for part 1. So we can find that. So what's section 16? Section 16 is a secretary. A foundation company shall have a qualified person as its secretary. Okay, and if you wanted to read more about that, you go to the Foundation Company Law Act itself, and it's a pretty short read here. There's only 4 subparts to it in section 16. Right? Shall continue to hold office until a qualified person has been appointed. Person who's not a qualified person may be appointed, subject to contrary provisions, blah, blah, blah. Okay? Section 8.7. A person ceases to be a secretary if section 8.7a. If the person dies or becomes bankrupt or being a corporation enters into winding up or is dissolved, or section 8.7b, if the person resigns as secretary by notice of the foundation company, and the resignation shall have effective immediately unless the notice states otherwise, provided that there shall be at all times a qualified person as defined under the law appointed as the secretary, and no secretary shall cease to hold office until a qualified person has been appointed and the secretary's place and the registrar has been notified. That's taken right out of the law. So no questions there. Section 9. We're now in section 9, general meetings. Section 9.1. The secretary shall convene a general meeting when required to do so by written request of section 9.1a, the founder, section 9.1b, any person who has the right to attend general meetings, which is a supervisor, or could be the beneficiary, depending on how the founder appoints the beneficiary, and section 9.1c, the directors. Section 9.2. The persons who have the rights to receive notice of and to attend and have one vote each at the general meetings are section 9.2a, the founder, section 9.2b, any members, section 9.2c, the supervisors, and section 9.2d, any beneficiary to whom the right has been granted by an unrevoked declaration under Article 7.1c. We talked about that already. Here's 7.1c, where the founder has the power exercisable by notice of the foundation company to declare a beneficiary that has an enforceable right. Okay. Now we're at section 9.3. General meetings shall be convened by not less than 21 days' notice. And in parentheses says, exclusive of the day on which the notice was served, in parentheses, to everyone entitled to attend, unless all persons entitled to attend agree to short notice or no notice. The notice shall state the place, day, and hour of the meeting and the general nature of the business to be transacted. Section 9.4. The accidental omission to give notice of a general meeting to any person so entitled, or the non-receipt of a notice of a meeting shall not invalidate the proceedings at that meeting. That's interesting. Let's make a question of that one. So our 29th question is page 11, section 9.4. Why does the accidental omission not invalidate the proceedings? Right? Why is that true? Because this gives kind of a loophole for a power play to occur. I think I noted this when I first read it. If they're not required, right? If accidental omission, and that accidental word can be loosely interpreted. I forgot to send you the notice, Mr. Supervisor. Sorry about that. But we held the meeting anyways, and it doesn't invalidate the vote where we voted you out, Mr. Supervisor. So sorry we forgot to tell you about that. It was going to happen. It was completely an accident. That's that loophole, right? So loophole. Meeting notice was forgotten to supervisor was not notified of meeting where supervisor was voted out. And remember, the supervisor is the eyes and the ears. He gets to to look at why decisions were made. You know what I mean? So if a specific decision was made while the supervisor was forgotten to be included, there's a loophole right there. So I'm going to mark that one up as bright blue because I added that. To supervisor. I just like to know what the reasoning was. I'm sure there's a reason for it. I'm sure the reason wasn't just to have a loophole. So I'd like to hear what that answer is. Because that can be used a lot to circumvent stuff. Accountability. Circumvent accountability. And I am big into that. Very big into that. Okay. 9.5. Section 9.5. No business shall be transacted at a general meeting unless a quorum is present in person or by proxy when the meeting proceeds to the business. The quorum is a majority of the persons entitled to attend and shall include the founder if the founder is alive and not incapacitated. Okay, so the founder is a required quorum member in order for business to be transacted at a general meeting. Now, my first question was, what was a quorum? We answered that. Quorum is a majority. My second question is, what is business? The foundation company's general nature of business is holding company securities. And okay, there we go. That is it right there. I don't know what that means because that was the question we had about whether or not SIBA, Securities Investment Business Act, was applicable. So I don't know what that means. Let's ask. Okay, page 11, section 9.5. No business shall be transacted at a general meeting. Okay, so our question is, what is business? And what we think it is, if we reference whatever that section was, that, oops, we think under section 2.1 that it is general nature of business is holding company securities. Just going to say that. It's going to reference that literally. And then we think, what else do we think? Oh, the quorum part. And that the quorum is a majority of persons entitled to attend and shall include the founder. So that's good to know. Reference 9.5. So these questions are getting a little bit advanced. This is the sort of stuff that will take attorneys quite some time to put together. So that's all billable hours. That's all costing stuff. So I've got to be cognizant of that. We're at question number 30, and some of these might require some intense or a lot of research. Okay, that's probably enough. Just those two. Let's go to our next one, and now we're at 31. So we'll make business a new keyword because in general meeting is a keyword. Okay. So what is business? Yeah. What is business? Okay. We're now at section 9.6. At any general meeting of the foundation company, unless the laws or the foundation company's memorandum of association, these articles or the bylaws otherwise provided, every motion proposed shall be decided by ordinary resolution of those present in person or by proxy and entitled to vote. So this is what I was talking about when I said about the accidental omission. So what if, not even what if, the loophole here seems to be that the accidental omission where the meeting had a 9.6 activity, which is a motion passed by ordinary resolution, the supervisor was not there to see it and did not catch it. And because of 9.4, that is not invalidated. I think that's true. So let's put that. Loophole 1. All right, so loophole 2 is a section 9.6 activity, which is a vote, is held, but to any person, right? To any person. So what if I accidentally omitted inviting the founder? The founder was accidentally omitted from the invite. Does the that's still there. That does it is it invalidated? Right? So activity, an ordinary resolution was passed. That seems to be like a glaring loophole right there. All right, so section 9.7. A resolution in writing signed by all persons for the time being entitled to vote at general meetings shall be valid as effective as if the same had been passed at a general meeting of the foundation company duly convened and held. All right, we already know that one. That's good. Section 9.8. A general meeting may be held and any person may participate in a meeting by means of a conference telephone or similar communications equipment by means of which all persons participating in the meeting are capable of hearing each other, and such participation shall be deemed to constitute presence in person at the meeting. So we're talking like Zoom or Discord call. I guess even an X space, right? Twitter X space is a similar communications conference, which all persons participating are capable of hearing each other. Yeah, that could meet the intent. So now we're on section 10. Proxies. Section 10.1. Any person entitled to attend and vote at a general meeting of the foundation company may be written instrument under hand, or if the appointer is a corporation, either under the corporation's seal or under the hand of an officer or attorney duly authorized, appoint a proxy to represent at the general meeting of the foundation company. All right, let's read that one again. Any person entitled to attend and vote at a general meeting of the foundation company may, by written instrument under hand, okay, or if the appointer is a corporation, either under the corporation's seal or under hand of the officer duly appointed authorized, appoint a proxy. Okay, got it. So any person who is allowed to vote at a general meeting may appoint a proxy to represent themselves at the general meeting as long as it's written. So I appoint X person to be my proxy. That is what this is. All right. Got to stay hydrated. Section 10.2. The instrument appointing a proxy may be in any usual or common form or as otherwise acceptable to the chairman of the meeting for which the instrument is first presented. I've not heard the word chairman before. I missed that. Oh, it was previously talked about in. Oh, we haven't gotten there yet. Section 11. So this is the first time we are seeing the word chairman. I don't know. We need to add that person to our rectangle of confusion. Know what I'm talking about? Our rectangle of confusion is this. So let's add chairman. That references to chairman. Let's do that. All right, let's do this. It's going to make it a little bit messy, but we need to talk about this person now, I guess. That looks a little weird, but we're gonna put in there. So chairman is apparently a part of this now. Let's go to our questions. So what would be our question here? It would be page 12, section 10.2. Who is the chairman? They aren't mentioned before. There we go. So the chairman is now a new buzzword. Let's find out. Section 11, directors meeting. This is fascinating, okay? Section 11.1, except as otherwise provided by these articles, the directors, so you can have more than one, shall meet together for the dispatch of business, convening, adjourning, and otherwise regulating their meetings as they think fit. Okay? Questions arising at any meeting shall, unless the laws or the foundation company's memorandum of association, these articles, or the bylaws otherwise provide, be decided by a majority vote of the directors present. Each director shall have one vote. In case of equality of votes, meaning a tie, the chairman of the meeting shall have a second or casting vote each. So the chairman is the tiebreaker. So let's break this one down. Actually pretty easy. The directors shall meet together for the dispatch of business, convening, adjourning, or otherwise regulating their meetings as they think fit. And questions arising from any meeting shall be decided by a majority vote, with the chairman being the tiebreaker. Okay, got it. Section 11.2. The secretary, on the written requisition of a director, shall at any time summon a meeting of the directors by at least 5 days' notice. And in parentheses says, exclusive of the day in which the notice is served, in parentheses, in writing to every director specifying the place, the day, and the hour of the meeting, and the general nature of the business to be transacted, unless notice is waived by all the directors either at, before, or after the meeting is held. That last part, though. Shall be transacted unless notice is waived by all directors. Okay, got it. So they need 5 days notice to do a meeting. They can do the meeting whenever else they want. Section 11.3. The quorum necessary for the transaction of the business of the directors may be fixed by ordinary resolution of the foundation company, and unless so fixed, shall be at least 2 of the directors then holding office present in person where 2 or more directors are appointed, and otherwise a quorum shall be 1 director. Okay, so they just clarify what quorum was. If there's only 1 director, then quorum is 1 director. And if you have 5 directors and you didn't specify what quorum was through ordinary resolution, then it's 2 directors. Okay. Section 11.4. Minutes of all meetings of the directors shall be signed by the chairman of the meeting or the next succeeding meeting, and a copy of the minutes shall be circulated to all directors and the secretary within 14 days after the meeting and in any event before the next scheduled meeting. Section 11.5. A resolution in writing signed by all the directors for the time being shall be as valid and effectual as if it had been passed at a meeting of the directors duly convened. Okay, so they could technically, in Discord, convene a meeting. Oh, they could pass a resolution on Discord if they wanted to. They could pass it in, I don't know, via text, like a group chat. That's the way this reads. Section 11.6. A meeting of the directors may be held and any director may participate in a meeting by means of a telephone conference or similar communications, like an X Space or Zoom, equipment by means of which all persons participating in the meeting are capable of hearing each other, and such participation shall be deemed to constitute presence in person at the meeting. Okay, got it. Section 12, registers. Section 12.1. In addition to the registers required to be maintained under the laws, the foundation company shall maintain a register of interested persons at its registered office, which shall, inter alia, record. Let's look at what inter alia means. Inter alia means among other things. So is inter alia the same as et al? No. While both inter alia and et al are Latin phrases used to indicate among other things or and others, respectively, they're not exactly the same thing. Inter alia specifically means among other things and is used when listing a few examples from a larger group, while et al is more commonly used to shorten a list of people or things by saying and others. Okay, I don't really know what that difference is supposed to tell me, but okay, got it. Which shall, inter alia, among other things, record, section 12.1a, the date upon which a person first shall became an interested person, and upon which the person ceased to be an interested person. The date upon which a person first became an interested person, and upon which the person ceased to be an interested person. Okay. Section 12.1b, the name of the currently designated representative of such interested person in the case of a corporate member. Oh, the proxy. That's the proxy. That's got to be section 10, what they're referring to. Okay. Section 12.1a, section 12.1c, the address of the interested person in the islands for services of notices. Okay. Section 13, accounts. We're getting there. Section 13.1, the director shall cause proper books to account to be kept for. Section 13.1a, all funds received or expended or distributed by the foundation company and the matters in respect of the receipt or expenditure takes place. And section 13.1b, the assets and liabilities of the foundation company. And proper books of account shall not be deemed to be kept if there are not kept such books as are necessary to give a true and fair view of the state of the foundation company's affairs and to explain its transactions. Such books shall be kept at the registered office or such other place as may be determined by special resolution of the company. Special resolution is 2/3 majority. Assets and liabilities of the foundation company as was first determined with the initial members and then accrued over time. And this is me reading into this. I'm done reading section 13.1 right now. And all right, let's reread section 13.1a. All funds received. All right, the directors shall cause proper books of account to be kept for all funds received or expended or distributed by the foundation company. Okay, got that part. And the matters in respect of which the receipt or expenditure takes place. Oh, like I guess a general meeting. And the matters. I don't know what "and the matters" means exactly. Let's make it a question since we already have 31 of them. What does "and the matters" mean? Here we go. Okay. Section 13.2. The books of accounts shall be open at any time in ordinary business hours to inspection by the founder, a supervisor, and any other person to whom a right of access has been granted under the foundation company's Memorandum of Association, these articles or the bylaws. Section 13.3. By notice to the foundation company, the founder or a supervisor may call for such reports, accounts, information, and explanations from the directors as to the administration of the foundation company as are described in the notice. Okay. Section 14, Auditors. Section 14.1, foundation company may, but shall not be required by ordinary resolution at any time, appoint or replace an auditor or auditors of the foundation company. The remuneration of an auditor shall be fixed by ordinary resolution. This is another new one, an auditor. All right, so we don't really know. These are just more and more and more people. Did I have auditor anywhere? Okay. In the foundation company's law in Schedule 2, that's where the Articles of Association. Oops, you can't see what I'm doing. There. So in the foundation company law, Schedule 2, which is where the model constitution is, and that's just a template association, Articles of Association, which a foundation company is not required to do. They're not required to abide by this model constitution. But as we learned, when we can compare the two side by side and SANDDAO 56, they are very similar. So when the foundation company, our foundation company, Sandbox DAO, was stood up, it used a lot of the same language from the model constitution and Schedule 2 of the foundation company's law on page 20 through 31. So in the Articles of Association, it talks about an auditor. At least it lists the auditor. And I'm willing to bet you if I were to pull it up side by side, it would list an auditor, same or similar language as this. Okay? Good to know. I think my only question is same thing as the chairman. On this time, it's page 14. It's section 14.1. Who is the auditor? They aren't mentioned before. Okay. Section 14.2. Every auditor shall have a right of access at all times and ordinary business hours to the books of account of a foundation company and shall be entitled to require from the directors and officers of the foundation company such information and explanation and access to vouchers and other documents as the auditor considers necessary for the performance of the auditor's duties. You know what? Actually, no. I just looked it up in the foundation company's law. It's not there. Let's take a look in the Companies Act. Let's look up the word audit. So there is a mention of audit in the Companies Act under section 59, accounts and audits. It talks about audits. Does it talk about an auditor? It does. Under section 43, under proceedings at general meetings, talks about business is being conducted, something about giving a report to auditors and fixing remuneration of auditors. So in the foundation's company law, it only mentions it in the template. And in the Companies Act, the big one, which is the big one in our reg stack, right? So that would be this one here, down at the bottom, that Companies Act there. So this big one has it in one of the sections. So sections 43, 100. Okay, so that's where it mentions it in here. And the foundation's company law, it mentions it in the schedule optional template for a company's Articles of Association, which the the Sandbox DAO Foundation used that template and used a lot of it. Okay. Section 15, winding up. All right. We're getting close. I think there's only 16 sections. All right, so winding up. Section 15.1. The foundation company shall be wound up if the founder delivers notice to the foundation company at its registered office declaring that it is to be wound up. The person designated in the founder's notice shall be the liquidator. Another word. But we know what the liquidator is because we talked about the liquidator in SANDDAO 56. I don't think, because the liquidator is only comes into play when they're appointed, so I don't think we need to really talk about them much. Okay, so the person designated in the that person designated in the founder's notice shall be the liquidator, or if no liquidator is so appointed, then the directors shall or such person as they shall appoint shall be the liquidator. The surplus assets shall be distributed to the founder or as the founder directs. That is okay. You know what? We first talked about this over in the memo. And here in section 10, we talked about if there are surplus assets, it shall be applied or distributed under the Articles of Association. Okay, now here is the Articles of Association saying the surplus assets shall be distributed to the founder or as the founder directs. So now we really want to know who the founder is. Okay, so let's go back to our question. Who is the founder? Who be the founder? Because they are about to get, not only do they have God mode privileges, but they also get everything, looks like. Where's our founder? Founder, 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 founder. All right, there we go. Oh, we didn't ask. Who is the founder? That's two questions. Let's stick to one question at a time. It's gonna mess up everything, won't it? Yes, it will. Oh, you know what? I can delete this question. And then add a new question 9 over here. Yeah, let's do that. Who is the founder? All right, and then our reference for why this is so applicable to us now is page 14, or just section 15.1, the surplus assets. Oh, we need a reference first, the MOA. And which part was it? Section 10. Shall be applied under the Articles of Association. This one is shall be given to the founder. Okay, good. Good stuff. We are deep diving deep into this, but we are excavating everything. There is very, very little confusion here. There are a lot of questions, but there's very little confusion about what's happening now. After we did all of these episodes together before today, so that's episode SANDDAO episode 34, SANDDAO 56, 57, 59. So much of this is now, like, instead of 100 questions, we have only 30 something now. We understand a lot more. So much more. Okay. Who is the auditor? They aren't mentioned before. All right, we were in here, winding up section 15. We had to go back here to section 9, or to question 9. To ask who the founder was and reference How shall it be applied? And then we need to rearrange this one so that it restarts at 10. And we are good. All right, back on track. Section 15.2. Members, directors, and supervisors as such have no power or authority to wind up the foundation company or petition the court to wind up the foundation company, except in the case of insolvency or for the purposes of a bona fide reorganization intended to enable the foundation company to carry out its objects more efficiently. I have a feeling this is one of the things that is undecided. Because right here, you're saying in the company that no one else has the ability to wind up the company except for the founder. But I see this as a point of clarification that may get challenged in the court and become case law. Because that's a pretty broad statement. Not broad. That's a pretty restrictive statement that no one else has the authority to wind it up when the founder isn't mentioned in the Companies Act, and it's only mentioned as an optional template in the foundation's company law. So you are designating an optional person to have the ability to wind up or liquidate or close down the company. Something tells me that that one is not could be challenged. So the question is how enforceable is when founders are optional roles? That's the question on that one. Okay. So let's read this again. 15.2. Members, directors, and supervisors as such have no power or authority to wind up the foundation company or petition the court to wind up the foundation company, except in the case of insolvency or for the purposes of a bona fide reorganization intended to enable the foundation company to carry out its objects more efficiently. So that also petition the court. I think that's probably why I believe that it's going to get challenged because you're restricting someone's ability to have legal remediation, a legal remedy, which in the U.S. that's a big no-no. You can't do that. In some cases you can, but in very, very particular cases, and the case law on that's super shaky. So that is, I think that's probably a point of, oh, you can't read what I'm saying. I'm sorry. This right here, I think that part of this sentence is suspect. Okay. So now we're on question 35. Whew. Now we're in section 16. We're four pages away. Indemnity and insurance. Now remember when we said indemnify, you will help pay for. Section 16.1. In this article, section 16.1a, an indemnified party means each of the founder, director, supervisors, secretary, and other officers of the foundation company for the time being, and any trustee for the time being acting in relation to any of the affairs of the foundation company and their heirs, executors, administrators, and personal representatives, respectively. I was about to add a whole bunch of people in our rectangle of confusion, but I don't think trustee is an actual role. I don't think trustee is an actual role in the foundation company. I think they're just mentioned as though if a trustee somewhere else comes and says, I need to be indemnified, I guess. Okay. Section 16(1)(b). Liabilities mean all liabilities, costs, charges, losses, including consequential losses, damages, fees, expenses, including legal and other professional fees and expenses, judgments, fines, penalties, interests, settlements, and other amounts, including with prejudice to the generality of the foregoing, any liabilities in respect of or in connecting with any proceedings. I'm talking about court proceedings there. Maybe ADR, dispute resolution proceedings, maybe that. Alternative dispute resolutions. Section 16(1)(c). Proceedings means all suits, proceedings, demands, claims, and actions of whatsoever kind, whether civil, criminal, administrative, investigative, regulatory, or otherwise. There you go. Section 16.1(d). Reference in this article to actual fraud or willful default mean a non-appealable finding to such effect by a competent court in relation to the conduct of the indemnified party. Okay. Section 16.2. Each indemnified party shall, to the full extent permitted by law, be indemnified on an after-tax basis out of the assets of the foundation company from and against all liabilities which the indemnified party shall or may incur or sustain, provided that no indemnified party shall be entitled to indemnification with respect to any liability to the extent that such liability resulted from an act or omission that constitutes actual fraud or willful default on the part of the indemnified party. 16. All right, let's break that one down a little bit. This is actually the definition here of how the indemnified party should be treated in 16.2. Each indemnified party shall, okay, fullest extent permitted by law, okay, be indemnified on an after-tax basis. So after they do their taxes, after they factor in their tax liability. So whenever you buy buy shoes and you have sales tax, it the person will be indemnified, reimbursed after taxes, I guess. After taxes are assessed. Of the foundation company from and against all liabilities. Again, up here, liabilities means all these things. Which the indemnified party shall or may incur or sustain. That right there is the indemnification part. All right, so against all liabilities which the indemnified party shall or may incur or sustain. And then they have this little asterisk here. All right, and the most important part is constitutes actual fraud or willful default. So if this indemnification happens and it's determined that the indemnified party has committed fraud or willful default, then the indemnification is no longer applicable. All right, but we're not done here. 16.2a is by reason of an act done or admitted to be done in connection with the business and activities of the foundation company. 16.2b, by reason of such person being a founder, director, supervisor, secretary, trustee, or officer. Or 16.2c, in or about the execution of their duty as a founder, director, supervisor, secretary, trustee, or officer. Okay. 16.3, unless the same shall result from an act or omission that constitutes the actual fraud or willful default by an indemnified party, no indemnified party shall be liable or answerable for 16a, the acts, receipts, neglects, or defaults of any other indemnified party. 16.3b, joining in any receipt for the sake of the conformity. 16.3c, the solvency or honesty of any banker or other persons with whom any monies or securities or tokens belonging to the foundation company may be lodged or deposited for safe custody. 16.3 delta D, any insufficiency of any security upon which any monies of the foundation company may be invested. 16.3e, acting on any advice or opinion given by legal advisors to the foundation company. That's a convenient one. Okay. That's a pretty big loophole there. 16.3, maybe loophole is the wrong word. That is a pretty broad protection right there. That's a big protection. So big, in fact, after I read that one sentence, that the indemnified party is not responsible or answerable for any act where they receive advice or opinion by legal advisors. So in our case, the DAO is TTA. And depending on who the indemnified party is, it could be anybody, I guess. It could be the director, could be supervisors, could be the founder, I think. I'm not sure. That's a question right there. Good question. So they could have unlimited indemnification so long as they acted on the advice or opinion given by a legal advisor. So seeing that, I'm now no longer confused as to why someone may or may not rely on legal's advice so much. Because if they do, and they're indemnified, they get broad waiver of liability. That's just within the foundation company, though. Someone can still sue them. That's how indemnification kicks in. And then section 16.3E. Who are the indemnified parties? This section grants broad liability waiver if legal is involved. If legal was involved in the action. Which who wouldn't have legal involved in a lot of that? So interesting. All right. And then 16.3F, any liabilities due to any such cases as aforesaid. I think aforesaid means said above us. What does aforesaid mean? Being the one previously mentioned or spoken of. I don't know what that's supposed to mean here in this sentence, in this list. 16.3G, any other liabilities when the foundation company shall or may incur or sustain by reason of any act done or omitted in connection with the business and activities of the foundation company, or by reason of such person being a founder, director, supervisor, secretary, trustee, or officer, or in or about the execution of their duty in their respective offices and trusts. Okay. 16.4. To the fullest extent permitted by law, amounts incurred by an indemnified party in defending or otherwise in connection with any liability or proceeding, whether as a party or otherwise, shall from time to time be advanced by the foundation company prior to a final non-appealable finding of a competent court that the indemnified party is not entitled to be indemnified upon receipt by the foundation company of an undertaking by or on behalf of the indemnified party to repay such amounts if there shall be a final non-appealable finding of a contempt court that the indemnified party is not entitled to be indemnified. Holy smokes. All right, the most important part in this whole thing is shall from time to time be advanced by the foundation company, meaning the foundation company may pay legal fees and all that stuff ahead of a court's finding or a court's resolution or verdict. 16.5. The indemnification provided by this article shall be in addition to any other rights to which an indemnified party may be entitled under an agreement as a matter of law or otherwise, both as to actions in the indemnified party's indemnified party's capacity as an indemnified party and as to actions in any other capacity, and shall be continued as to any identified party who has ceased to serve in the capacity in which such identified party became entitled to indemnification under this article. Oh my gosh. All right. Give me a second. Let me eyeball this again. All right. I think I'm not fully understanding this, but I think the first part here, the indemnification provided in this article shall be in addition to any other rights to which an identified party may be entitled under any agreement. Okay, that's the first important part. The second important part is, and shall continue as to any identified party who has ceased to serve in this capacity, in which such identified party became entitled to indemnification. So, meaning this last part means that if someone is no longer indemnified, but at the time they did this action, they were indemnified, they shall be treated as having been indemnified now by the foundation company. Okay? So if the director was indemnified and was entitled to this indemnification 5 years from now when they are sued, and it was determined during when they did this, they were indemnified. Then 5 years later, the foundation company shall treat them as indemnified, so pay for their stuff. Okay. 16.6. No amendment, modification, or repeal of this article or any other provision of these articles shall in any manner terminate, reduce, or impair the right of any past, present, or future indemnified party to be indemnified by the foundation company or the obligations of the foundation company to indemnify any such indemnified party under and in accordance with the provisions of this agreement as in effect immediately prior to such amendment, modification, or repeal with respect to any liability arising from or relating to matters occurring in whole or in part prior to such amendment, modification, or repeal, regardless of when such liability may be arise or be asserted. Jeez, that's a lot to say this first sentence. No amendment, modification, or repeal of this article or any other provision shall in any way terminate, reduce, or impair the right of the indemnified party to be indemnified. That's it. The rest of this is good, I guess, but legalese that just kind of gives you your assertions and assumptions and stuff. That's the way that reads to me, at least. Section 16.7. How many more? Okay. Section 16.7. Any amendment, modification, or repeal of this article, or that otherwise affects this article, that limits its scope shall be prospective only. Prospective means, I think, not permanent. Relating to or effective in the future, likely to come about. Yeah. So future. Not yet put into practice. And shall not in any way affect the limitations on the liability of the identified parties under this article as in effect immediately prior to such amendment, modification, or repeal with respect to any liability arising from or relating to matters occurring in whole or in part prior to such amendment, modification, or repeal, regardless of when such liability may arise or be asserted, provided that the identified party became an identified party hereunder prior to such amendment, modification, or repeal. Okay. Got it. Section 16.8. The directors, on behalf of the financial company, may purchase and maintain insurance for the benefit of any indemnified party against any liabilities or proceedings. That rings a bell. Secretaries are required to have insurance, I think. Is either that or directors? I don't remember which one. Let's take a look here for a second. Insurance. Oops, that's the wrong one. This one. One of them had to have insurance. Yeah, okay. So if our director was licensed under the DRLL, Directors Registration and Licensing Law, they would be required to have insurance. But if our director is not covered under by this, then they are not required to have insurance. But 16.8 says they may purchase insurance. Okay. Section 17, which is in error called the Constitution. If you look at SIP number 1, I think it's about time we go over that. SIP number 1. Okay. Down at the bottom, we get into the Constitution. But if you click the Constitution, it will bring you to the bylaws. And per Cayman Islands law, not policy, not interpretation, per the law, the bylaws are not part of the Constitution. All right, we went over that in SANDDAO 56. All right, so if we talk about the Constitution, let's actually search bylaws. All right. Bylaws are optional, but as specified in Section 2 of the Foundation Companies Law, the Constitution means the memo and articles of the foundation company, but not its bylaws. So, where this is called the Constitution, just know that it's the bylaws and not the Constitution. I think that was just an error. So, Section 17, bylaws. Section 17.1. Founder, by notice of the foundation company or the foundation company by special resolution, may adopt bylaws that are not inconsistent with the laws or the memorandum of association or those articles or these articles. So, okay, may adopt bylaws. They're already optional per law, Cayman Islands law, which are now called acts. There's a lot of stuff that's different. Section 17.2. Bylaws may relate to any aspect of the business or affairs of the foundation company or any of the duties or powers of the directors or the delegates or others who have duties or powers under these articles, including the way of achieving the foundation company's objects. Remember, the objects were in the very, very, very beginning of this whole podcast episode, which is the whole reason why this thing exists. All right, continuing on. The benefiting of beneficiaries, the investment, management, and protection of the foundation company's assets, the remuneration of directors and their delegates, the delegation of the directors' duties and powers, the supervision of the management of the foundation company, and the appointment of the advisors and other service providers. Okay, that's a mouthful, but that's actually a pretty important one. So this is saying that the bylaws has the ability to expand on almost everything. There's a lot. There's not a lot that this doesn't include, in my opinion. You got the objects, which is everything the foundation company does, beneficiaries, the investments, the management, the protection of the assets, the remuneration, which is all of the compensations, payments, of the directors and delegates, and their delegates. Those are the proxies and their delegates. They're proxies. Duties and powers, supervision, appointment of advisors and other service providers. Like, this is almost everything right here in this one subtle, unassuming paragraph at the end. So the Constitution is only 8 pages, so we'll get through that today. 8 pages is not a lot. 17.3. The bylaws may be varied or revoked by the founder by notice to the foundation company or by special resolution of the foundation company. There it goes again. That founder is able to do anything. 17.4. The adoption or variation of bylaws shall not render any director or other person liable for prior conduct. It's like almost an indemnification thing going on there. The adoption or variation of bylaws shall not render any director or other person liable for prior conduct. Oh, that's just a retroactive statement saying that the new, whatever you, if on Monday you have something that's not saying that you can get in trouble for signing something in red ink, but then on Tuesday you adopt a bylaw variation that says you will get in trouble if you use red ink. The person who signed the thing in red ink on Monday is not going to get in trouble on Tuesday for the new variation saying that red ink now is bad to sign with. That's what this is saying. It's called a retroactive clause. Okay. This is not retroactive. I think that's part of jurisprudence across the world. I might be using that term wrong, but basically like law theory that, I mean, you can't be helped. Never mind. We're going to keep going. 17.5. No third party dealing in good faith with the foundation company need be concerned with the bylaws or their observance. So there we have it. This just puts into place what is already part of the Cayman Islands law. All right, let's keep going. Almost there. Section 18, alteration of the memorandum and articles. Section 18.1, the memorandum of association and these articles may be altered in accordance with Clause 11 of the memorandum of association, and no other alteration may be made, which is in any way inconsistent with Clause 6, 10, 11 of the memorandum of association. Refer back to what I said when we first went over this. It's the same thing under the memorandum of association. We already talked about this one. Same thing. Okay. Section 19, financial year end. 19.1, the company's financial year end will be 31 December or such other date as the directors determine. Okay. Are we done? Made it. This was dated 20 November 2023. Signed by International Corporation Services Limited, ICSL. Remember, ICSL is being run, the principal agent is, right, I don't want to misspeak. Give me a second. ICSL. Yeah, the key principal for ICSL is Michael Alberga, who is a partner of TTA, who is the legal counsel SIP2 hires into Sandbox Foundation. Okay? All right, just a reminder. So this article of association is signed by ICSL, by this authorized signatory person, and witnessed by this person. Odds are this person is a government official, I think. It's a witness, though, maybe not. And then this person is an authorized signatory of ICSL. Okay? The end of the articles. Holy smokes, that took forever. Oh my gosh. Oh, Lord. All right. We do have one final question. Let's go back to that really, really important paragraph. Let's make a question out of this because I was not expecting. And when I first read this, it wasn't obvious to me that that was so powerful. This seems to. So we're talking about 17.2, this broad thing where bylaws can do anything. This seems to encompass everything about the TSB DAO Foundation. Does this section exclude anything? So as in, is there something the bylaws can't touch? There. So we're going to highlight our buzzwords. And there's our 36th question. Okay. All right. That was our Articles of Association as part of the Constitution. Okay? So there's our agenda item down there on the bottom. Done. Next is the bylaws. It's only 8 pages, so I mean we're already 4.5 hours into this. We're gonna keep going. Can't believe 4 hours. 4 hours. All right, next up are the bylaws. We are going to take a quick 2-minute break. We'll be right back.